Hey, what's up, Internet? We're going to do something a little bit different today. In my first video, I talked about wanting to incorporate some legal topics into the content on this channel, kind of interspersed throughout the guitar and music theory videos. So today, I wanted to jump into that and cover some copyright basics that I think it's beneficial for musicians and bands to have some awareness of as they're writing and thinking about how to protect their own music. So just to be clear, A, this is only about U.S. copyright law. B, I am an attorney. I'm pretty well versed in copyright and trademark issues, but absolutely nothing in this video or on this channel generally is meant to be or should be construed as legal advice. And there's no attorney-client relationship here. If you have specific legal questions, you need to talk to an attorney that's licensed in your jurisdiction. Every specific situation is going to have a unique set of circumstances that's going to dictate what advice an attorney is going to give you. So again, if you're seeking specific legal advice about your situation, you should absolutely talk to an attorney. All that I'm doing here is giving a brief overview of some of the basics of U.S. copyright law. It's going to be geared toward musicians, just to help you get an idea of the things to think about, and what type of questions you might want to ask as you are creating your own music, and if and when you ever do consult with an attorney about any copyright issues that you have. Cool? Cool. So, what even is a copyright? The go-to legal definition is that copyright law protects original works of authorship that have been fixed in a tangible medium. So what the fuck does that even mean? One, it has to be an original work. For the originality requirement, it's got to be independently created, basically meaning that you can't be ripping somebody off. And courts have said that it has to have a modicum of creativity. So the bar there is actually pretty low, because courts don't want to be in the business of deciding what constitutes art by deciding what gets copyright protection and what doesn't. Copyright law also only covers certain types of works. So there are literary works, paintings and photographs, drawings, sculptures, movies and TV shows. Architectural works can actually be covered by copyright, and there's a whole bunch of other stuff. But for our purposes, obviously copyright law also covers musical compositions, including any words that go with the music and sound recordings. So most of the music that we listen to has two copyrights associated with it. There's a copyright in the musical composition itself, so the chord structure, the melody, the lyrics, the arrangement, all of that kind of thing. And that's generally but not always owned by the artist or artists that wrote the music. And then there's a separate copyright in the actual sound recording. So somebody recorded and mixed and mastered that song, and a lot of times that copyright is actually owned by the record label. A copyrighted work also has to be fixed in a tangible medium. Basically, that means it has to be physically recorded in some way. That can be as simple as writing it down. So if I wrote out a script for a YouTube video, for example, and saved it in a Word document, or even if I wrote it out with pen and paper, boom, I have it fixed in a tangible medium. That counts. Whether I wrote out a script or not, once I recorded a video and it automatically saves on my phone or my computer, boom, fixed in a tangible medium. I don't even have to upload it for it to be copyrighted. If I was giving a lecture, though, in front of a live audience and nobody was recording it or writing down anything that I said, it's not fixed and I don't have a copyright. If I've got a guitar riff that I wrote like 3 years ago, and I play it all the time, but I've never written it out on paper or recorded myself playing it, then I do not have copyright protection in that guitar riff because I haven't fixed it in a tangible medium. But let's say that we've met all the requirements for copyright protection. What rights does that actually give us? Depending on how you count, there are about 6 things you get to do if you have copyright protection in something. Probably more importantly, you get to stop other people from doing those things. So what I think are probably the 4 most important things that you get are: you get to reproduce that work or make copies of it. You get to create derivative works, which are works based off of that original work. You get to distribute your work to the public, and then you get to publicly perform and display that work. So there's kind of a lot to break down there, and more than I'm going to have time for in this video. But generally speaking, copyright protection gives you an exclusive set of rights to do the things that are going to allow you to profit from the music you've created. And it's going to allow you to stop other people from doing those things with your music. The whole thinking behind copyright laws is that if somebody is creating meaningful art, we want them to be able to profit off of it so that they can stay focused on creating instead of having to go to law school. So, who owns a copyright? Like we said, if you record a song for a record label, the label is most likely going to own the copyright in that specific recording of the song. If you record a demo in your basement and mix and master everything yourself, you'll own the copyright in that sound recording. But what about the song itself? Generally speaking, unless you transfer your rights, you're going to own the copyright in any original music that you create. But let's say you're in a 4-piece band and all 4 of you contribute to the writing process. If the 4 of you write a song together where all 4 of you contribute to the song, then all 4 of you are going to be copyright owners in the song. And that's what we call joint authorship. And all 4 of you are each actually going to own 100% ownership of the copyright in the song. So if your bass player wants to sell out and sell that song to Toyota so that they can put it in their next Camry commercial, he doesn't have to get your permission to do that, and there's nothing that you can do to stop him from doing it. But unless there's some agreement to the contrary, all of the profits from the song are going to be split evenly between the copyright owners. So the good news is you'll probably get some cash out of that. So how long does copyright ownership last? It's not indefinite. Generally speaking, if your song was written after January 1st of 1978, which it probably was, then the copyright protection is going to last for your entire life and then 70 years after that. So it's the life of the author plus 70 years. If you're in a joint authorship situation, the protection is going to last for 70 years after the death of the last surviving author. Now, probably the 2 most important copyright questions that a musician can ask are, 1, do I have to register my copyright to get protection? And 2, if not, should I register my copyright anyway? And the short answers to those 2 questions are no and probably. Going back to the legal definition of copyright, it's an original work of authorship fixed in a tangible medium. That doesn't say anything at all about registration. So registration is not required to get copyright protection. So let's lay out a hypothetical real quick. Let's say that an artist writes and records a song. They put it on an independent album that they then put up on all the streaming services, and they've never registered any copyrights. 2 years go by, and another song comes out by another artist, and the first artist is absolutely convinced that artist 2 ripped him off. Before artist 1 can bring a lawsuit against artist 2, artist 1 does have to register their original song with the Copyright Office. They would either have to register the song or get a refusal from the Copyright Office before they took it to court. But the protection would predate the registration by at least that 2 years, because as soon as artist 1 had recorded the song, thereby fixing it in a tangible medium, they had given themselves copyright protection in the song. So anybody that ripped them off after that would be on the hook. Before they actually took it to court, though, they would have to register it. So registration also has a whole bunch of other benefits. And honestly, it's not super expensive or complicated. I'm going to put a link to the Copyright Office and some PDFs that they have that are really helpful down in the description. But looking at their website earlier today, I think the standard registration application fee is $65. There are a couple things you have to do to file an application, but I don't think it's as much as people probably expect it to be, honestly. Looking at some of the other benefits of registration, so you get to enforce your copyright in court, obviously. That's kind of important. As long as you register a work within 5 years of its publication, then your registration establishes prima facie evidence in court that your copyright is valid. It lets you establish a record with the U.S. Customs and Border Control, so that if somebody's trying to import a whole bunch of goods that infringe your copyright, they can stop it. And the biggest and most important one, in my opinion, is that if you register your work before somebody infringes against it, then you can get statutory damages, attorney's fees, and costs, which basically means that you can get a lot more money if it ever does go to court and you end up winning. So, long story short, you don't have to register anything to get copyright protection. But registration and doing it before somebody tries to rip you off can have some pretty serious benefits. Another simple way that people protect their copyrights is by providing copyright notice. It's also not required, but generally not a bad idea. Usually it includes either the copyright symbol, which is the little C with the circle around it, or the full word copyright, the year that the work was published, and the name of the owner of the copyright. So essentially it just puts people on notice that, hey, this is my work, I own it. And it also lets people know who to contact if they're interested in using your work in some way, and generally they'll have to pay you for it, so that's cool too. So that's all that I've got for today's video. Again, please remember, absolutely none of this was meant as specific legal advice. I just wanted to do a really basic overview of some of the aspects of U.S. copyright law that I think it's probably good for musicians and bands out there to have at least some knowledge and understanding of. If you have specific legal questions, I very highly recommend talking with an attorney. If you enjoyed this video, it would be awesome if you'd go ahead and give it a like, and please subscribe to the channel. Help me appease the YouTube gods. Check out my other videos while you're there. Most of them are guitar and music theory lessons. I put a whole lot of time into making the free lesson PDFs. And I plan on getting a few videos similar to this one up soon, and you'll also be able to find some backing tracks on there here soon. I'm not sure if I've mentioned it on the channel before, but I do give private guitar lessons via Zoom, and if you're interested in that, the email I use for lessons is down in the description, along with some of those helpful links that I talked about. Thank you, Internet. Peace.